Next is with relating to the burden of proof. Section 105 of the Indian Evidence Act says, if the accused person claims the protection of right of private defence or under any of the defence under what a general exception, the burden is upon the accused person. This is an irrebuttable presumption. This burden will be discharged by showing preponderance of probability in favour of the plea on the basis of material on record. Section 99 states the circumstances in which there is no right of private defence. There is no right of private defence. The first one is, there is no right of private defence against an act done or attempted to be done or by the direction of a public servant. The public servant must have done the act in good faith and under colour of his office, even though the act may not be justified by law. The second condition is, there is no right of private defence in a case where there is time to recourse the public authorities. The mere fact that the police station is very far from the place of incidents cannot deprive a person of his right of private defence. The third one is, there is no right of private defence, or in no case private defence shall extend to infliction of more harm than is necessary for the purpose of defence. If the public servant acted bona fidely under authority, but going beyond his authority, the accused has a right to exercise private defence on the ground of exceeding his authority. With respect to the second limitation, a person is not entitled to claim right of private defence merely on the ground that he is acting under the directions of public authority, but this information shall be communicated to the accused or the person concerned. The section ensures that the right of private defence can be exercised till he comes to the knowledge that the person is acting under the directions of the public authority. So, it is essential that the fact shall be communicated to the person concerned. If the person, if suppose for example, if a police officer who is acting under the authority or under the order of the court and the same information is not communicated to the other person, to the accused person has the right to exercise private defence. But the section categorically says that this order, under what authority he is acting, this order or this information shall be communicated to the other party, after that he can act upon. With respect to third limitation, when the accused continued to assault the deceased after he had fallen down and rendered harmless, it was held that there was no right of private defence. Section 100 provides the right of private defence of body extend to the causing of death to the assailant. If the offencer is an assault of any one of the following description: first one, an assault resulting in the apprehension of causing death. The second one is an assault resulting in the apprehension of causing grievous hurt. The third one is an assault with the intention of committing rape. The fourth one is an assault with the intention of gratifying unnatural lust. Fifth one, an assault with the intention of kidnapping or abduction, and the last one is an assault with the intention of wrongfully confining a person, which may reasonably cause the apprehension that the man may not be able to contact public authorities for help. See, this section 100 is based on 4 principles. First one is, the accused must be free from fault in bringing about the encounters. The second one is, there must be present an impending peril to life or the great bodily harm. The third one is, there must be no safe or reasonable mode of escape by retreat. And the last one is, there must have been a necessity for taking life. These are the 4 essential ingredients or essential principles which is underlined in section 100. The right of private defence cannot be based on surmises and speculations. The accused must be under a bona fide fear that the death or grievous hurt would otherwise be the consequence of the assault if he does not defend. Killing in the exercise of right of private defence would be justified only if there was an honest and well founded belief in the imminence of danger. It is not necessary that actual injury should be caused by the aggressor or the victim before the right of self-defense can be availed of. Person apprehending danger is not required to wait for sustaining injury. Mere reasonable apprehension is sufficient for exercising the right of private defense. So, that is very important. In order to exercise right of private defense, it is not necessary that the victim should suffer any injury, or mere apprehension of injury is enough to exercise right of private defense. Further, section 106 says the right of private defense also extend to the taking of risk to life of innocent persons under the following circumstances. First one is there is a reasonable apprehension of death. The second one is the person is so situated that he cannot effectively exercise the right of private defense without doing harm to innocent persons. So, that is very important. Under section 106, in order to exercise the right of private defense, it may cause injury to an innocent person, that is immaterial. The first law which under the first principle which is included under section 96 to 106 is self preservation. In order to protect himself, a person can cause harm to an innocent person. Under section 103, the right of private defense also extends to voluntary causing of death to the assailant in the case of danger to property resulting from any one of the following offences. First one is robbery, second one is housebreaking by night, third one is mischief by fire to any building, vessel used for dwelling purposes or custody of property. The fourth one is theft, mischief or house trespass under such circumstances as may reasonably cause the apprehension that death or grievous hurt may be caused. Right to private defense of trespasser. The Supreme Court in Puran Singh vs. State of Punjab laid down 4 criteria which the trespasser may entitle to exercise right of private defense of property and person. First one is the trespasser must be in actual possession of property over a sufficient long period. The second one is the possession must be in the knowledge either express or implied of the owner or without any concealment and which contains an element of animus possidendi. The third one is the process of disposition of the true owner by the trespasser must be complete and final. And the last point is one of the usual rest to determine settle possession of the true owner by the trespasser in the case of cultivable land would be whether any crop has been grown on the land. If the crop has been grown, even the true owner has no right to destroy the crop grown by the trespasser. As per the provisions of section 101 and 104, the right of private defense of body and of the property extends to the voluntary causing of any harm short of death to the assailant. This is applicable in respect of cases other than those mentioned in section 100, 103 and 106. The next is when the private defense commences and when this private defense ends. This is a very important question, because since when a case came before a court of law, the first question is when the private defense of a person commences and when it ends. If a person committed an offence, suppose the victim committed or accused person committed an offence in the name of private defense, after the completion or after the end of exercising private defense, then it will not be counted as a private defense. So, that is very important to determine when the right of private defense begins and when it ends. It is specifically mentioned in section 102 and 105 of the Act, which says that the right commences as soon as reasonable apprehension of danger to human body or to the property arises from an attempt or threat to commit the offence, though the offence may not have been committed. The right comes to an end as soon as the threat of assault has ceased and the apprehension of danger has been removed. So, that is very important. So, the section very categorically says, when a danger to a body or property commences, then the right to private defense starts. When the danger to the body and the property ends, when the right to private defense comes to an end. In the case of theft, the right of private defense continues till the offender has effected his retreat. In the case of housebreaking by night, the right of private defense commences so long as housebreaking continues.